We're joined now by former federal prosecutor Doug Burns and lawyer Elliot Felig from Elliot Felig and Associates, our all-star legal panel. And we need you guys on a day like today because there is a lot to break down. Certainly two big developments, as we mentioned, with Manafort and, of course, with Michael Cohen. And Elliot, you're nodding as I say Michael Cohen because that does seem to be the more significant one. Break down the charges there.
No question that's the more significant one, because in that case, you know, just a few miles from here in the Southern District of New York in a courtroom, the president's former personal attorney stood in the well of a courtroom under oath, described criminal activities, and said they were coordinated at the direction of the president of the United States. It's a big deal no matter how you slice it.
Doug, how would he prove that they were coordinated at the direction of the United States?
Well, that's a great question, because what you're going to start hearing for those detractors of it, first of all, I agree with my colleague Elliot that it's a significant development. I mean, the Manafort trial is more political type of soundbites because we all agree that it did not involve conduct while he was involved with the Trump campaign.
Right.
But this one, involves these two payments. And now for the first time, we do have a witness who said under oath, by the way, because the plea proceedings are under oath, that it was done at the direction of the candidate. So on some levels, it was interesting that they felt the need to throw that in. It wasn't necessary, by the way, to his plea, but they did it. Everybody's going to be micromanaging it and analyzing it, but it is a significant development.
Okay, so assuming that they have credible evidence that clearly shows that this was at the direction of the President of the United States, Elliot, it's a campaign finance violation.
Right.
Is it a big deal?
No, well, it's a significant campaign finance violation. People do get prosecuted, have been for many years, for exceeding campaign contributions, for funneling campaign contributions through employees. Dinesh D'Souza, the famous documentarian, was convicted and had to go to a halfway house for about a year for simply having an employee give a sham contribution, money that he had reimbursed to a friend of his who was running for U.S. Senate. So it is a big deal. The best thing the president has going for him in terms of not winding up in the well of the Southern District is that there are pre-existing DOJ guidelines that say you can't indict or you won't indict. As a policy, it's not a hard and fast law, but as a policy, as sitting president. So ultimately, if it is found that the charges are credible, and given that we have a guilty plea, they seem pretty credible, it becomes a political matter, because it would be, if there's going to be a sanction, it would probably be through the mechanism of impeachment.
But here's the ironic rub on all of this, really ironic. Elliot's correct. There are these two Department of Justice memos from the Office of Legal Counsel, one in the 70s, the other one more recent, that, point out and opine that you can't indict a sitting president. We've covered that many times. But the point is, for impeachment, hello, everybody, he wasn't president when those things happened.
So does that mean then that it wouldn't apply?
I think it's going to be a tough uphill battle to say that he did a high crime and misdemeanor while in office when it didn't happen when he's in office. I mean, these are not political sound bites by me. I'm just telling you one of the legal realities.
Absolutely, and that's what we like from you, Doug, the legal realities. Any way that they come. But a legal reality comes to mind of John Edwards.
Well, I'm glad you said that, because,
set the background for us there.
Yeah, I mean, I understand Elliot's point, and he's right. Some people have been prosecuted for it, but at the same time, I think there's a significant political risk that the other side's going to overplay this a little bit, making it sound like the crime of the century, which it's not, as you've calmly pointed out, and I agree with you. But I think politically, everybody's saying, A, will the House of Representatives, end up with a Democratic majority, but B, the Senate, even if that happens, by the way, hypothetically, the Senate's unlikely to turn, and it's a 2/3 vote for impeachment anyway. So I'm looking at it more, working off his point about how you're not going to indict a sitting president. I'm looking at it, beyond my pay grade as an impeachment matter, and I don't think he may be impeached, which to everybody means charged. People get confused. I don't think he's going to be convicted necessarily.
So I don't even know that he'll be impeached. Impeachment is, by definition, a political process. It's designed to be a political process. The Constitution is intentionally vague in terms of describing what constitute high crimes and misdemeanors. It's left to the Congress, the duly elected, our representatives, to decide it. And it's not clear at all, even within the Democratic Party, at this juncture, if there is a consensus for impeachment. There are a lot of people who think that that would actually be politically a mistake, that it would lead to blowback. It kind of burned back in the Republican space in 1999 when they tried to impeach Bill Clinton.
So, worst case scenario based on the campaign finance violation, what are the legal implications for the president?
Look,
no, I think, again, I think there are no implications in the sense that I mean, if you already concluded that the Office of Legal Counsel said you're not going to indict a sitting president, I mean, I'm being mildly sarcastic and saying you're certainly not indicting him for this, okay? Citing John Edwards. So then you go into the discussion we just had, which is impeachment.
Okay, but now we don't know if Michael Cohen may have more on the president. Is there an indication that he may cooperate, that he isn't cooperating? Can we speculate on that front?
So the plea today was not a cooperation agreement, for example, by contrast with Flynn.
Correct.
Flynn's sentencing, for example, has been postponed over and over again, presumably because he's still cooperating and he can't be sentenced until that cooperation is done. This was not a cooperation agreement. He's getting sentenced in 3 months unless he jumps on a plane to someplace where we can't extradite him from. He's going to get sentenced in 3 or 4 months. So
can we assume anything from that? Can we assume that if he had something else on the president that would have come out, or is this pending a longer conversation with T. Mueller?
I have no doubt, though, that the plea today was preceded by detailed conversations where he shared everything he does know about the president's involvement in these activities. I don't think they would have agreed to the plea otherwise.
And the inclusion of that language about I did this at the direction of and in coordination with was something that was specifically worked on and hammered out and agreed to. But what's fascinating, working off your question, seriously, is Elliot's right. It's not a cooperation agreement. And by the way, in cooperation agreements, they don't put a predicted range of sentence, by the way, so that tips us experts off. In a cooperation agreement, they leave that out. So we know that it's not a formal cooperation agreement. But your point's a good one. That doesn't mean that he might not at some point cooperate. And then the fancier point, he already cooperated today by saying what he said in the plea allocution. Very
quickly, Paul Manafort. Any implications there for the special counsel? Because the president said he feels sorry for Paul Manafort, but it has nothing to do with a witch hunt. Is this a done deal now?
I think the time for Manafort to flip is long past. Either he doesn't want to or he doesn't have anything of interest, but I don't think it's happening.
And usually 99% of the time after you convict somebody at a trial, they don't even want to entertain cooperation. I had said that to you once before on your show. Here, they might make an exception. The other real quick point worth noting is they will not, will not go forward and retry the 10 counts from today, because a conviction on 8 is essentially the equivalent of all 18. It doesn't matter.
That would just be greedy.
Yeah.
So that's enough now, Paul Manafort.
But the other question is, will they go
Virginia
forward?
Trial.
Will they go to the other trial, though, in D.C.? I have no idea. What do you think?
I think he's going to have to plea if he wants to get out of the Virginia. They might reduce the plea. They might make it just 1 or 2 counts instead of the, whatever mountain he's facing. But I don't think they'll just walk away from it outright.
All right. Elliot, thank you so much. Elliot Felig and Doug Burns. Appreciate your legal analysis, as always.
My pleasure.
Well, meanwhile, the